The serene marble facade of the United States Supreme Court building in Washington, D.C., betrayed none of the seismic activity occurring within its chambers on Monday morning. As the clock approached 10, the gathered crowd of reporters, legal scholars, and a handful of anxious political operatives hushed, their attention fixed on the live feeds. The release of orders and opinions is a routine procedural event, but in this term, under this political climate, routine had become an antiquated concept. The air was thick with anticipation for rulings on a dozen high-profile cases, each one holding the potential to alter the nation's political landscape in an election year. What emerged, however, was a unanimous decision so stark in its clarity and so sweeping in its immediate implications that it momentarily silenced the perpetual noise of American politics. In a 9-0 ruling, the court repudiated a core legal theory advanced by former President Donald J. Trump's legal team, a theory that had formed the bedrock of his defense against multiple state and federal investigations. The court's opinion, authored by the Chief Justice and joined in full by both its liberal and conservative wings, was less a legal nuance and more a demolition. The specific case, United States v. Alvarez, was a technical matter concerning the statute of limitations for certain financial crimes and the ability of prosecutors to access sealed grand jury materials from prior concluded investigations. Legally, it was a narrow channel. Yet the justices chose to navigate it in a manner that sent a tidal wave crashing into adjacent legal battles, most notably those involving the former president. The ruling effectively gutted the argument that a sitting president's official acts created an impermeable, time-limited shield for all associated conduct, private or otherwise. For Mr. Trump and his inner circle, the decision was not merely a loss, it was a catastrophic and unexpected realignment of the judicial terrain upon which they had carefully constructed their fortifications. Sources close to the legal team, speaking on condition of anonymity due to the sensitivity of the matter, described a scene of stunned disbelief as the opinion was scanned and digested. The unanimity was the gut punch, a scenario their strategists had dismissed as a near impossibility given the court's ideological divisions and the three justices appointed by Mr. Trump himself. The immediate practical effect was to reinvigorate several investigations that had appeared stalled or constrained. Federal prosecutors in multiple districts, who had been meticulously building cases while navigating a thicket of procedural challenges, now found a series of roadblocks removed by the court's opinion. A senior Justice Department official, who was not authorized to speak publicly, confirmed that the ruling clarifies a significant jurisdictional issue and would allow previously constrained lines of inquiry to proceed with greater dispatch. Legal analysts across the spectrum were united in their assessment of the decision's gravity. "This is a watershed," said Rebecca Thorne, a constitutional law professor at Yale University and former federal prosecutor. "The court has unanimously rejected an expansive view of executive immunity and procedural delay that has been leveraged not just by this former president, but by others before him. It is a profound reassertion that the legal process, though deliberate, cannot be indefinitely suspended by claims of privilege that extend beyond a president's time in office." The ruling's impact was felt most acutely in the Manhattan District Attorney's Office, where an investigation into business and financial records had been painstakingly assembled. The case, which had once seemed on the brink of being sidelined by federal preemption arguments, now surged back to the forefront. Prosecutors there were reportedly convening an emergency strategy session, reviewing evidence that could now be presented to a grand jury under a newly clarified legal framework. Simultaneously, the Georgia state investigation into alleged efforts to overturn the 2020 election results received a substantial boost. The state-level prosecutors had been contending with arguments that their probe infringed upon federal executive authority. The Supreme Court's opinion, while not directly addressing state jurisdiction, established principles that legal experts say severely undermine such a defense. The Fulton County District Attorney's Office released a terse statement acknowledging the ruling and affirming its commitment to following the law wherever it leads. Internationally, the decision was passed by allies and adversaries alike for its implications on American political stability. In capitals from London to Beijing, diplomats and intelligence agencies reassessed their near-term forecasts for the United States. A protracted legal battle had been a central variable in their models. This ruling compressed the timeline dramatically. The unanimity is the key signal, remarked a European Union senior foreign policy advisor, speaking under standard diplomatic protocol. It suggests the American legal institution, despite immense pressure, has reached a breaking point regarding certain defensive claims. The political ramifications within the United States are immediate and turbulent. For President Trump's potential rivals in the emerging 2024 Republican primary field, the ruling creates a treacherous new landscape. Do they distance themselves from a figure now facing accelerated legal jeopardy, or do they double down on claims of a weaponized justice system, a narrative that remains potent with the party's base? Early statements from likely candidates were cautious, focusing on abstract principles of justice rather than the specifics of the case or the former president's predicament. Democratic leaders, while publicly cautious about commenting on an active legal matter, privately expressed a sense of vindication. Many had argued for years that the Department of Justice and other prosecutorial bodies needed to pursue evidence without fear or favor, an approach they felt was hindered by ambiguous legal doctrines, now clarified by the court. The ruling effectively raises the political stakes of every subsequent indictments or hearings, ensuring they will occur under the blinding glare of a presidential campaign. Financial markets, often a bellwether for institutional stability, reacted with notable volatility. The ruling introduced a fresh layer of uncertainty into an already complex economic environment. Analysts suggested that the prospect of a major political figure engaged in simultaneous high-stakes legal battles during a campaign introduces non-economic risk factors that are difficult to price, leading to sharp sentiment-driven movements in key indices. Behind the scenes, the former president's legal team is in a state of frenetic recalibration. Their strategy for the past 2 years has been predicated on delay, on navigating the slow currents of appellate review, and on pushing any potential trial dates beyond the political horizon of the 2024 election. This ruling, in several key respects, has pulled that horizon much closer. The prospect of facing jury trials in state and federal courthouses while actively campaigning is now a tangible, daunting scenario. The human dimension of this legal earthquake should not be overlooked. For the investigators and career prosecutors who have worked on these complex cases, often under intense public scrutiny and political condemnation, the Supreme Court's decision is experienced as a validation of their professional rigor. "We just kept following the facts, even when the path seemed blocked," one federal investigator shared, echoing a sentiment heard in several offices. The court has now said the path is clear, the work can proceed. Historical parallels are being drawn, albeit cautiously, to other moments when the judiciary has intervened decisively in matters of profound political consequence. Scholars reference United States v. Nixon in 1974, which compelled the release of the Watergate tapes, and Bush v. Gore in 2000, which effectively decided a presidential election. This ruling, however, is distinct in its preemptive nature. It does not decide a case against the former president, but it systematically dismantles the legal architecture designed to prevent such cases from ever being decided. The court of public opinion now becomes a critical and unpredictable theater. Polling conducted in the immediate aftermath of the decision shows a stark partisan divide, but with a significant shift among independent voters. A narrow majority of independents, according to one flash poll, now believe the investigations should proceed without further delay, a notable increase from previous surveys. This suggests the shield of political persecution may be less effective with this crucial demographic when endorsed as legally unsound by a unanimous Supreme Court. International media coverage has been pervasive and sober. Outlets from the BBC to Al Jazeera have led their broadcasts with analysis of the ruling, framing it not merely as an American story, but as a case study in the resilience or fragility of democratic institutions globally. Editorials in major European newspapers have largely characterized the decision as a necessary corrective, a reassertion of the principle that no individual is above the law, a foundational tenet often touted by the United States in its foreign policy. Within the hallways of the U.S. Congress, the reaction is fractious. The Democratic-controlled Senate remains largely silent, with leadership emphasizing the separation of powers. The House, however, under its current Republican leadership, is a cacophony of conflicting responses. Prominent allies of the former president have already begun drafting letters of condemnation, alleging judicial overreach and vowing investigative hearings into the weaponization of the federal judiciary, a move legal scholars say has little practical merit but significant political theater value. The ethical dimensions for the three Trump-appointed justices, Gorsuch, Kavanaugh, and Barrett, will be intensely scrutinized. Their joining of a unanimous opinion that so directly undermines the legal position of their benefactor is a powerful statement of judicial independence. Conservative legal circles are abuzz with analysis, some expressing dismay at what they see as a missed opportunity to cement a broader theory of executive authority, others praising the justices for prioritizing the integrity of the judicial process over partisan loyalty. Looking forward, the procedural dominoes will begin to fall with startling speed. Motions to dismiss based on the now rejected theories will be withdrawn or overruled. Grand juries that were in a holding pattern will be reconvened. Requests for evidence previously stalled will be granted. The legal calendar for the next 18 months, which once seemed malleable, is now hardening into a series of immutable dates. The slow grind of justice has found a new insistent rhythm. For the broader American public, weary from years of political and legal warfare, the ruling presents a moment of stark clarity amid the noise. It is a reminder that the mechanisms of state, though often slow and imperfect, retain a core operational integrity. The unanimous verdict from the nation's highest court serves as a rare point of consensus in a divided land, a foundational legal principle restated not by politicians or pundits, but by the guardians of the constitutional order. The business community, a traditionally cautious constituency, is watching developments with acute concern. The entanglement of a leading presidential candidate in multiple simultaneous criminal proceedings presents a scenario for which there is no modern precedent. Corporate boards are quietly tasking risk committees with modeling outcomes, from political instability to changes in regulatory enforcement, that could arise from the unprecedented situation now unfolding. In the realm of legal strategy, the Trump team's options have narrowed considerably. The path of frontal assault on the legitimacy of the investigations has been severely undercut. The focus will now likely shift to procedural minutiae, appeals on evidentiary rulings, and efforts to change venue tactics of delay still, but of a more granular and less broadly defensible kind. The aura of invincibility afforded by a seemingly impregnable legal theory has dissipated. The role of the media in the coming phase will be critically important and intensely challenging. The responsibility to report on complex legal proceedings accurately, without sensationalism, while also contextualizing their political significance, is a formidable task. Editors in newsrooms across the country are holding meetings to reinforce standards, anticipating a barrage of spin, misinformation, and hyper-partisan commentary aimed at muddying the clear waters of the court's opinion. Academically, this ruling will be dissected for generations. Law review articles are already being outlined, debating the nuances of the court's textual analysis, its reading of historical precedent, and its implications for the balance of power among the branches of government. It is, in the view of many scholars, a classic example of judicial restraint being exercised in a way that produces a substantively powerful outcome. The court did not seek out a battle, but when presented with a specific question, it answered with unambiguous force. On a personal level for Donald J. Trump, the ruling represents perhaps the most significant professional and legal setback of his career. A man who has built a brand on defiance, on overcoming obstacles through sheer force of will and litigation, now confronts a wall built not by political opponents, but by the very institution he helped shape. The psychological impact on his campaign strategy, typically one of relentless offensive, is yet to be seen but will undoubtedly be profound. The international intelligence community is reassessing its posture. Adversarial state actors who have previously sought to exploit American political divisions through influence campaigns now face a coultered landscape. The predictable timeline of legal delay has been compressed, potentially reducing a key vector for sowing discord. Conversely, the heightened political tension itself presents a different kind of vulnerability, one that foreign disinformation networks may seek to exploit with renewed vigor. Within the Democratic Party, a fierce but quiet debate is underway between the pragmatic and progressive wings. The pragmatic center urges caution, warning that any overt celebration of the ruling could be framed as partisan gloating and backfire politically. The progressive left sees a moment to press for the most aggressive application of the law, arguing that the American people deserve a full and speedy adjudication of the facts before entering a voting booth. The ruling also touches upon deeper philosophical questions about the American experiment. It is a test of whether the system's designed checks and balances can function when one of the checked individuals commands the fervent loyalty of tens of millions. The unanimous decision is a strong data point in the affirmative, but the ultimate answer will depend on the public's reception of the legal processes that now follow, and their willingness to accept outcomes they may politically disagree with. For the legal profession itself, this is a moment of introspection. The theories advanced by the former president's lawyers were not frivolous. They were argued by eminent attorneys and entertained by lower courts. The Supreme Court's stark rejection serves as a reminder of the profession's duty, not merely to advocate zealously, but to ground arguments in principles that sustain the system as a whole. It is a lesson in the limits of advocacy when confronted with the judiciary's role as guardian of institutional integrity. As the sun set on Washington, the ramifications continued to ripple outward. The news cycles, which typically move at a breakneck pace, seemed to pause, locked on the analysis of this single event. In bars and coffee shops, on social media and around dinner tables, the conversation was singular and sober. A line had been drawn, not by a political party or a cable news host, but by the 9 justices in robes. The path ahead remains fraught, complex, and uncertain. But the landscape itself has been irrevocably changed. The strategic assumptions that have governed American politics for the past several years have been upended. The political class from both parties is scrambling to adapt to a new reality where the judicial process, long viewed as a slow-moving backwater, has reasserted itself as a powerful, immediate, and unpredictable force. The 2024 election will no longer be fought solely on inflation, immigration, or foreign policy. It will be conducted in the long shadow of courtrooms. The coming days will see a flurry of legal filings, strategic political statements, and media dissection. But the core fact remains immutable and historic. In a decision that shocked the political world, the Supreme Court of the United States with one voice has spoken. It has rejected a vision of expansive post-presidential immunity and cleared the way for justice to proceed according to the evidence. The nation and the world now watches to see what follows.